All right, let me see. Mr. Harris, is he available?
Your Honor, we went through all the laser discs, and we only had the highlighted portion that we show on two boards. One with the cover highlighted, and then pulling out the highlight. We only showed the laser board. All of our presentation was shown.
Your Honor, I don't even remember seeing a laser on this. All I remember having counsel tell me was showing me a report. You know, I would not have taken counsel to sidebar and objected to something had I known what he was going to do. As a matter of fact, I would have objected strenuously ahead of time had I realized that he was going to take one line out of context, outside of a paragraph.
All right, you understand the difficulty I have here. I mean, you've been given an opportunity to litigate it, now you want to come back and do it again. That's my problem. Where's Mr. Harris?
I'm going back to the office, Your Honor.
About the laser disc would be used in reopening, should you permit it.
All right, Ms. Clark, there's really something that I can't deal with then if the laser disc itself, the exhibit that they showed you, is in fact gone, because I need to make a factual finding as to whether or not there was some, that you were misled in some way as to what it was.
I'll tell you, Your Honor, I don't recall seeing a laser disc.
Well,
Ms.
Clark, let's look at the laser disc and see what's there, because that's pretty much frozen in its state. You know, that's not easy to manipulate, so let's take a look at it. Unfortunately, we probably won't be able to see it for quite some time. Since Mr. Harris is on his way, we'll have to catch him and bring him back.
But, Your Honor, I can represent to the court that we did not have the document here on Monday. We had only the laser disc, and the court required that we go through and show everything.
Which is why, Mr. Douglas, I'd like to see the laser disc.
But why was it only being shown to us on Monday? Why wasn't it shown to us on Friday?
No.
No, I'm
Ms.
serious.
Clark.
You know something, Your Honor? This is very unfair. The defense was required to show all their exhibits to us on Friday, as we did for them. We sprung nothing on them. They came marching in Monday with twice as many exhibits as we were shown on Friday. We were expected to absorb everything in a nanosecond and come up with cogent objections to each and every item. And that's very unfair. The people were put at a great disadvantage at having to absorb a great deal in a very rapid amount of time and come up with an objection as to each and every item. I don't think it should be all that surprising that I couldn't remember seeing one of about 50 new exhibits that was thrown at me Monday morning before our opening statements were to begin. And that alone should cause the court to realize that the people were put at a disadvantage with respect to being able to make intelligent objections to all of the wealth of new information that was unjustifiably thrown at us at the 11th hour. We should be given more time at this point.
Did you ask for any additional time at that point?
I did, and the court was... I indicated to the court at the time, Your Honor, that I did not have an opportunity to examine it carefully, and you asked me to immediately go through board by board and exhibit by exhibit with about 10 seconds for each. There really was not a lot of time. The court is concerned, I understand, about having the time of the jury spent fruitfully, and I'm mindful of that, and I appreciate that. And the court, was feeling the time constraint, understandably so, and so was I. But the result of what has been misconduct by counsel in failing to turn over exhibits in a timely fashion should not inure to the people's detriment, as it has been. And I think that's very unfair.
So you're saying that last Monday, the 23rd, just so I can check the record if I have to. All right. I'm not going to take up that issue unless and until I see the actual Laserdisc exhibit, which has unfortunately left the courtroom. That leaves me with Gerchis and the arthritis experts.
Okay, and with respect to those witnesses, which the court knows we were not informed of, either their names or their statements or their proposed testimony, we would ask leave of the court to address the jury with respect to the fact that we were not apprised of their intention to call such witnesses to describe the defendant's physical condition at the time of the murders, and that had we known, we would have discussed that with the jury at greater length, putting on the exercise tape. counsel showed us photographs of the defendant's body that they intended to introduce, but those photographs gave us absolutely no notice that they were going to be presenting testimony concerning rheumatoid arthritis. The existence of Howard Weitzman, that was another matter that was not turned over to us in discovery. The name was not even on a witness list. Had we known that they would make these representations to the jury, that Mr. Weitzman was excluded from the conference room, we would have been able to address the jury on the fact that not only did that not happen, but the officers are very well aware that would be a violation of law. As a matter of fact, it's something that is contained in the Miranda advisement, that Mr. Weitzman was in fact pointedly invited in with Mr. Simpson, that he declined to remain with Mr. Simpson, and himself decided to leave the facility. And we would have told the jury all about that. We would have even maybe read the Miranda advisement to the jury so they can understand that this is an obligation of the police to afford anyone who appears with his attorney the right to have the attorney present during questioning, and that Mr. Simpson was so advised, and that he elected to proceed without the presence of his attorney, and we could have done all of that. But counsel, as a matter of fact, we have that waiver on tape. Counsel's aware of that. But yet counsel deliberately chose to make a statement that was false to this jury concerning Mr. Weitzman. Had we known he intended to do so, and had we known that Mr. Weitzman intended to so testify, we would have put that before the jury. Furthermore, all of the evidence with respect to the circle of benevolence, the charity and the gift giving, we had no discovery of any of that, Your Honor. That defense counsel wanted to present that. And with respect to at least the representation of anonymous gift giving to links, we believe that we will have evidence to demonstrate that to the extent money was given, it was not anonymously given. And we would like to present to the jury the fact that the amount given to charity was minuscule compared to the amount of net worth this defendant had. And so we would like the opportunity to counter some of that evidence, which was also still has not been turned over in discovery. Still, only knowledge we have of that is the representations of counsel in his opening statement to the jury. Furthermore, with respect to Skip Taft, I believe counsel, again, this is another name that was not put on the defense witness list, for whom we have no statement, but counsel represented that Mr. Taft would testify concerning the contents of a prenuptial agreement.
Is there any dispute about that?
I believe there is. May I have a moment, Brad? were certain representations made with respect to what Skip Taft would testify to in that prenuptial agreement, that he would testify to the circumstances surrounding it, and it was represented to this jury as being another act in the circle of benevolence, that in fact it was a civil compromise attempt and nothing more by the defendant in an effort to get to pressure Nicole to withdraw her support for the prosecution of that case. And we would like the opportunity to address the jury as to the truth of the circumstances under which it was written. I just can't, it doesn't come to mind at this moment. But that's for starters.
Mr. Bailey?
If it please the court, in asking this court to set what I think would be a precedent in criminal cases, the prosecution now wishes to escalate that remedy to a full-blown rebuttal of things they wished they thought of when they gave their opening statement. They knew before they opened that Mr. Simpson intended to exhibit his scarred and torn-up knee to the jury and claim that he was disabled to a degree. They had the exercise tape. They elected not to play it. Now, in retrospect, it seems a bad idea that they didn't. Since you have stricken from our opening the names and any summary of what they might say of the witnesses enumerated in your order, it seems to be most anomalous to silence us and let the prosecution get up and trash them without rebuttal, making wild statements like Rosa Lopez is an O.J. Simpson fan when she's never met him, or Nicole. Furthermore, all this claim of surprise on Rosa Lopez is totally incredible. You will recall that as part of our offer of proof in response to the government's demand to you, we cited two preliminary incidents, both occurring on the 13th, which showed bad faith on the part of Mark Furman. One was the glove, and the other was suppressing a statement that Rosa Lopez had given him. It was in the papers. It was faxed to the government on Sunday the 8th. It was argued orally here, and was in part, I guess, the basis for your ruling, together with the Anthony case. Mr. Cochran, long after the statement was taken and before this representation was made to the court, personally wanted to verify that she claimed that she had made those statements to Furman. And on that basis, we asserted it to Your Honor. I never heard it denied in the course of the whole argument. I don't think Rosa Lopez is any part of any reopening. Perhaps, perhaps as to Gertjes, if some admissible information can be gotten, the court might permit this now thoroughly trashed woman, who's never had a day to appear, although she's expressed an interest in doing that, to be impeached, if in good faith they claim, and they, as officers of the court, assure you that they will produce on the witness stand under oath people who will testify that she has made the statements attributed to her. I'm not talking about judgments now or check cases. I'm talking about impeaching statements. If those representations can be made in good faith, perhaps, Your Honor, might permit them to talk about it. I haven't heard another thing in all of Mrs. Clark's presentation that makes any sense at all as reopening as a remedy for the sanctions, as part of the sanctions you've imposed. Insofar as the blood evidence is concerned, we have an assertion of fact, could not have come from Nicole Simpson, an attempt to bail out by somebody who obviously is in the prosecution's corner, speculating that if the blood were degraded, AB might have shown up as B, and therefore that would explain it without bringing in another party. We showed that on the screen. It's in the statement. If we had it to do all over again, I don't think any court could compel us to link the author's speculation with his established fact, and that's all that second sentence is. We pay it no importance at all, and we don't think that it's going to pan out. But in any event, in opening statement, we're entitled to show the jury those things that favor us. Now, apart from Ms. Gertsch's, I don't believe Your Honor should permit any of what has been requested by the prosecution. It is nothing more than a chance to come back and rebut the defense opening statement. They could have handled all of these matters beforehand if they had thought about what they were doing as carefully as Mr. Cochran did when he laid out his very detailed presentation.
Ms. Clark?
With respect to the blood argument just given by Mr. Bailey, he demonstrates nothing but his ignorance. As a matter of fact, what Mr. Matheson put in that report is a matter of established science. We are talking here a matter that is the subject of treatises that are many years old. It is a known fact that the EAP marker is very labile, that a BA degrades to a B very rapidly, and the court can envision it. You have 4 bands in this marker: heavy band, faint band, heavy band, faint band. The faint bands are A, the heavy bands are B. The faint band, being A, degrades first. BA goes to B very rapidly. It's a known thing, which is why when there's evidence of degradation and you have a B result on the EAP, you cannot exclude the BA. And that is something that the jury has been completely misled about. Not to mention the fact that at least on the thigh marker, where counsel told the jury that it excluded her as well, there was faint A activity. So, I mean, there's been a...
I'm not prepared to really make a ruling as to the blood issue until I see the Laserdisc exhibit to see whether or not there is some real danger of the jury having been misled there. I'd like to hear your observations on Mr. Bailey's argument that you were aware that there was going to be some allegation that Mr. Simpson was unable to, because of his arthritic condition, unable to physically to even contemplate committing these acts. Why it didn't occur to you, knowing that, to play the exercise video during your opening.
When did we know that, Your Honor? When does counsel allege that we knew that?
When the motion was made for the defendant's right to address the jury during opening statement.
Which was on Monday.
Right.
Which we objected to.
Before your opening statement.
That's right, which we objected to. But being able to show a scar, which is what my argument was to the court at the time, has nothing to do with doctors who are going to testify to rheumatoid arthritis. There was no offer of proof forthcoming with respect to how that scar was going to be linked up. I repeatedly argued to the court, what is the probative value of showing the jury a scar? Believing that that's all that the defense would do, I elected at that time to let it be. Because I did not think that counsel, because counsel did not give us discovery. This is the problem with being sandbagged, Your Honor. Counsel never gave us discovery of the fact that the doctors were going to be rheumatoid arthritis specialists, were going to come forward and link up that scar to something meaningful in terms of his physical capabilities on that day. And counsel deliberately and willfully did not inform the court or the prosecution of his intent to link up that scar to a doctor's testimony. Now, how was I able to anticipate what counsel was going to do when he willfully withheld that information?
All right. Now, Ms. Clark, let me ask you one other thing. Can you make an offer of proof to the court that you will have witnesses, as to Ms. Gertsch's, who will testify to inconsistent statements, such as telling other persons that she was truly not there, that she was not in fact looking for a condo or apartment in that area? Any other specifics regarding credibility, specifically as it comes to this case?
Yes.
Tell me about that. You can make that representation
Yes.
that you will have those witnesses?
Yes.
All right, any further comment, Ms. Clark?
With respect to Rosa Lopez, I can only indicate, Your Honor, that we were unfortunately sandbagged badly in that respect as well. Upon reading the transcript, I was stunned to realize that counsel attributed many statements to her that allegedly were made to Detective Furman on the morning following the murders, when in fact his own statement indicates that all she said to Detective Furman was she heard noises. It took an extensive and exhaustive review of the transcript to realize, to go back to find exactly what those statements were. And counsel then reiterated it again today to this jury, which compounded the harm in his failure to turn over that report, which we still don't have.
Right.
We still have no statement indicating that.
Mr. Cochran, is there no report about that?
Absolutely none, Your Honor, if I might respond.
Then how do we know that then?
because we went and talked to the witness, we talked to her, they had to report, when we got the report, Your Honor, they had this is a key witness, obviously. They know that she talked to Furman that morning. Don't they have an obligation, do we have to do their job also, Judge? Don't they have an obligation to talk to Rosa Lopez like I did? There's no further report. That's the thing that's so amazing about what they're saying. We don't have to do their investigation, Judge. We're the defense in this case. We don't have to do their investigation. This is unprecedented. You have them whining and moaning. This is just opening statements. We haven't even started the trial, Judge. And all this emotional, vitriolic, everything is misled, and everything they do is perfect, everything we do is wrong, and we are just doing our job, Judge. And it's absolutely incredible that she sees all these exhibits and all these things and wants to rehash everything with you, Your Honor. We offered that these things should be over at some point. We ruled on the other things. Yet we have to relitigate everything over and over and over again, Your Honor. And I don't think that's fair. It's not fair to Mr. Simpson.
You know, Your Honor, I'm appalled. You know, what does counsel think is his job, to mislead and to sandbag and to ignore the law and to flaunt the law?
All right, counsel, I'm just
Okay.
asking for, I just asked Mr. Cochran for an explanation. Is there a statement of Rosa Lopez that contains attributes to her the comments that Mr. Cochran made today and the day
Right.
before?
This
That
is
was
their
my
witness.
question.
Yeah, this is their witness. And when they take a further statement from a witness, they're obligated to turn that statement over, and as we always have. There have been multiple statements for some witnesses in our case, and the prosecution has never been derelict in its duty, has always fulfilled that duty to
All right.
turn all of them
Well,
over.
Ms. Clark, here's the problem. There's been a representation made to me that no such witness statement was taken. All right?
Nevertheless, obviously, the statements were made, weren't they? And we were given no notice of the fact that the witness made further statements that are of a much different nature.
When that witness is called, you may make a new objection, and I will contemplate precluding that witness from testifying, based upon the fact that it appears that at the time of opening statement, there was a clear intent to do that no statement was in existence, that additional statement was not disclosed. I've already made finding as to other witnesses that this failure to disclose was intentional and deliberate. You can renew your motion then, but at this point, I'm not going to entertain any further sanction as to Rosa Lopez.
We would not ask the court to preclude her testimony, Your Honor. We would ask an admonition be given concerning her testimony.
All right. All right, court will rule as follows. The prosecution will be allowed to briefly reopen its opening statement. It will be allowed to go into inconsistent statements, specifically with regard to this case, regarding Mary Ann Gerchis. Prosecution, because the defense did not disclose the identity and nature of expert witnesses who would be testifying regarding arthritic condition, may merely say that now that we know that this is going to be an issue, we're going to show you this videotape or these outtakes. Prosecution may mention the fact that Howard Weitzman was having not been disclosed, that the information that you have, the evidence you will present, will be that that was not in fact what happened, that Mr. Weitzman was in fact allowed, or however you feel the evidence will come out as to that. As to the allegations of misleading the jury regarding the EAP blood types, I'm going to defer ruling on that until I've seen the laser disc. I'm going to sustain the court's own objection under 352, undue use of the court's time as to the circle of benevolence argument and the Taft prenuptial agreement, because I don't think there's any that's a matter of interpretation that can be done through the evidence and not through presentation of argument through opening statements. All right, and Ms. Clark, I'm going to give you a 10-minute time limit on that.
Everybody else, but we're going to need. I would like for the court to, I would like to await the presentation of the opening statement until we know the court's decision on the blood issue.
That's a much different issue. That doesn't go to sandbagging at discovery. That goes to the show and tell issue. That's a different issue.
But the resolution of it is the same, really.
Not really.
What other resolution could there be?
Well, that's a completely different issue that I'm not going to entertain until I see the laser disc. All right? But we have an hour left of court time. There are other sanctions that I can impose besides that, but I'm not convinced that a sanction is appropriate in that case.
With respect to that laser disc?
That's correct. I want to see the exhibit itself. If the exhibit, this is my thought on that. If the exhibit, although highlights one section, if the rest of the sentence is visible and there's a complete sentence available, that was exhibited for a long period of time in great detail to the jury. It may not have been misleading in that context. And Ms. Clark, please don't misunderstand me. I realize the pressures that you're under, both professionally and otherwise, and I really appreciate them. But at some point in time, when we have our show and tell and we make rulings and we agree not to, or we waive objection to things, that should be the end of it.
I appreciate that, Your Honor. I think that
I agree with you, that's an important part. I agree with you, that's an important issue. But I need to see it before I can rule on it. I've given you something that's virtually unprecedented in any criminal case I've ever seen, the opportunity to reopen, but it's a sanction I think that's available to me within the spirit of 115. But those are the only 3 items that I'll allow you to reopen on. And you have a 10-minute time limit. All right, now, after we finish that, then what are you going to present? I understand there's a tape recording I need to listen to.
yes.
What is that? Tape recording of what?
Let me defer.
Mr. Darden?
Your Honor, 2 matters. We have not seen any video outtakes. We'd like to see them before the jury does. And I respectfully suggest, Your Honor, that you might wish to repeat the exhortations the counsel made on the opening day. I do not believe that personally directed epithets add any grace whatsoever to this proceeding.
I was actually, Mr. Bailey, I think I've spent a lot of time jumping on them today. So I was waiting for one of you to do that so I could jump on you to make the point, so.
Prefer the high road.
All right. I have to balance my excoriations from time to time.
You wanted some information?
Yes, Mr. Darden, what I'd like to know from you is you indicated to me at sidebar off the record that you were going to present apparently the audio tape of the 1989 or 1985 9/11 call.
Yeah, the 911 call from 1989. Yes.
1989.
Yes.
All right. And also you indicated that in the course of the reopened opening statement that you were going to present outtakes from an exercise video. Is that correct?
That's correct.
When did you receive those outtakes?
When did we receive the outtake? We received the outtake some days ago, and we pressed them onto a laser disc yesterday.
All right. Well, let's see what they are. Let's see what they are.
Also, there's a cut version of the Roy Firestone interview, which they have not seen,
It's called edited.
edited.
Anything else, John?
I advised Mr. Cochran of the Firestone interview editing earlier.
Mr. Bailey, you had a comment?
Yes, Your Honor. Mr. Cochran has suggested to me, and I endorse the notion, that in fairness to this witness who's been battered all over the courtroom for merely having the unpleasant experience of being a witness, that we might have a hearing on these alleged impeaching witnesses to see if they exist and what they really say before the jury is given that taint, which we can't undo for 3 months. Could they be brought in and appear before Your Honor just long enough to assure us that they exist and they have such testimony to give? Pretty good job has been done on Mary Ann Gersha so far. We're going to find our witnesses going to other countries pretty soon.
I'll think about that. But at this point, let me see these other items. Do we have the laser disc of the...
Yes, Your Honor. This is a full cube tape of the 10-minute segments of outtakes.
Before we play that, can we approach without the reporter for a moment?
Sure. Counsel. All right, I've been advised that the outtake material is still copyrighted material. So its release to the outside video feed will be interrupted for the playing of this item.
As I understand it, Your Honor, will last approximately 10 minutes.
All right, counsel, it's 10 minutes after 4 right now. I still need to hear the audio tape, still need to hear argument, et cetera, on that. I don't think we're going to finish with the jury today. My inclination is to send them home at this point.
As far as the audio tape is concerned, it's the same audio tape that I assume the court listened to back when we did the motion to eliminate regarding the DB.
Yeah, but by the time I finish watching 10 minutes of video outtakes, and if there's some objection to specifics, by the time we finish that argument, it'll be 4:30. You're ahead of the game right now, Mr. Darden, anyway. Deputy McNair, why don't you call up and let the jury loose for this afternoon? Thank you. All right, let's see the outtakes. All right, let's see that.
I'm sure that I will need to change.
What's the copyright status of this material?
Your Honor, I'm not sure at this point in time.
Yeah. Ready? Sure.
On 3 occasions in the last 8 years, O.J. Simpson appeared on this program with me. A segment that originally aired in 1989. I asked Simpson about his pleading no contest to a charge of an assault on his wife, Nicole.
The day after this was over, we looked at each other. We had a fight. We were both guilty. No one was hurt. It was no big deal, and we got on with our life. As a matter of fact, after the Rose Bowl, we hosted a party for a great deal of amount of people, and mostly our friends. Took a trip with a couple of friends who never even knew we had an argument that night, and then 30 days later, I'm reading in the paper this major thing had happened, quoting things that people say to one another in the middle of an argument, right and wrong. I mean, it wasn't all right what you read in the paper, But it was embarrassing, but because our relationship was strong and all our friends knew it, and they knew what they were reading wasn't necessarily the truth, hey, we just tried to put it behind us and ignore it as much as we could. I mean, we could have easily gone to court and been on the stand, and I think even the city attorney's office realized that they couldn't have won it, but that wasn't the point of filing. The point was to bring attention to a new law that's on the book, and who better do that than me? And I just said, why me? Why am I the guy that you choose to do this? I don't think I'm a good example, and I don't think this incident this night was a good example of what you guys are trying to, bring to light.
That is the end of this particular segment.
All right. How long is the audio tape? I'm sorry?
I am removing the tape from a exhibit that has already been sent to court. It is tape labeled T55.
testify, and she will authenticate. Okay.
I have a moment, Your Honor, I'm not quite familiar with this new tape that can request
Well, he's searching for the goods, Your Honor. What is this remedial to? Obviously, Mr. Darden could have played it in his opening, decided not to.
No, this is the, you objected, lodged some objection to this. This is part of our 402 hearing as to the tape.
Okay, this has nothing to do with reopening.
No, but I figured since we're here, we sent the jury home, we got all the equipment, we might as well listen to it all at one time.
Yes, he's gonna listen to us at some point about the video and the other thing.
Is the Firestone tape also something coming into evidence, not for reopening?
Yes,
Okay.
correct. The only thing that we watched for the purpose of the reopening was the workout tape.
Fine. And as to that, I assume that if you permit them to describe it and show it reopening, it will be on a commitment that it will be introduced in a case in chief, and that it's admissible for all purposes and not some limited purpose.
I assume so.
All right.
Yes. Yes, they were.
misplaced plug.
Proceed. A little more volume on that.
You calling from 360 North Rockingham, apartment number B?
Okay, please hold on.
So from Wilshire, Normandy at the highest. Suspect one is a male black, 5'10", 150 to 160, 25 years of age, wearing blue jeans, dark colored top. Suspect number 2 is a male black, 5'7" to 5'8", 150, also 25 years of age. Continuing wearing on dark clothing. Weapon used was .38 revolver. The vehicle suspect went in was going to be an 84 Buick blue. It's going to be one John.
Okay, let me give you this part.
Wearing a gray sweater.
Incoming woman, 5514 Sierra Vista Avenue, apartment 102. 5514 Sierra Vista Avenue, apartment 102. Female swimmer for Albany, located in code 2 items, proceed to 677.
7040, I'll need an ETA for my tow request.
Normandy at the Hyatt. Suspect described as a male black 5'10", 150 to 160, 25 years, wearing blue jean and a dark colored top. Number 2 is a male black 5'7", 5'8", 150, 25 years, wearing dark clothing. Weapon used is a .38 revolver.
911 emergency operator 72.
Buick. License 1 John Adam Henry 129, 1 John Adam Henry 129, last seen westbound Ulster. RV taken with $16.
7040, disregard.
West LA and any available West LA and Screaming Woman 360 North Rockingham Avenue, 360 North Rockingham Avenue, apartment number B. Female we heard screaming over the phone in West LA and close to high incident 1376, 9813.
I don't know, sir. No, ma'am, why? What's the problem?
Turn the volume up during the middle of the screens initially. As I said, the dispatcher would be here to authenticate the tape.
Yeah, I couldn't tell what was the part they're trying to play. It's not clear.
You wanted to hear the tape?
Can we go back to what he's trying to actually tell the jury? It's not clear about what we heard all the
All right, well-
The whole thing?
Yeah.
Can you play that?
That was the whole thing.
There's actually, no, there is more. It relates to other calls.
In his opening statement, he said we were going to hear slaps.
You will.
And, who's going to identify and authenticate that? Who do they have that was there can identify and authenticate slaps?
The dispatcher. And if you listen to the tape, you can hear it too. And as I said, I think we turned the volume up during the middle of the screens.
Your Honor.
All right, well then, let me hear it from the top then, because that's all at the beginning of the tape.
So I would like to hear that again. Because
I'd like
the
to-
dispatcher tell us there's slaps. She can't do that.
Well, that's why we're having a 402 hearing, Mr. Cochran.
That's why we have a jury.
Yes,
Let the
Your Honor,
jury.
But no, the point I'm trying to make. And
Oh, I understand the
forgetting,
point, counsel,
is
but
that
let's listen to the tape.
Yes. okay.
Some things are,
Did you hear the screaming though?
I didn't stand up and whine and moan when you made that statement, Your Honor.
Oh, I'm not
well,
whining and
now
moaning,
you
Mr.
give me the
Cochran.
opportunity. Gentlemen, really, this is getting out of control, and ladies, this is getting out of control going back and forth. You can make the same points, you don't have to engage in the personal invective. There's only one thing that really irritates me. I'm very patient, I let you guys talk a lot, but the thing that irritates me is the personal invective. All right, let's hear it from the top. I'm sorry? Okay.
Hello? You calling from 360 North Rockingham, apartment number B?
Let me ask you this, Mr. Darden, what generation tape is this? Is this a first generation off the large 24-hour reel-to-reel that LAPD has?
It's a second generation tape, I believe, off the reel-to-reel.
Right.
Shall I proceed?
Please.
Emergency operator 461. Hello? You calling from 360 North Rockingham, apartment number B?
Thank you. I'm sorry? No, let me see everything that we got. Let's do all the show and tell, and then we'll take them one at a time. All right? Mr. Harris, so good of you to come back.
I should indicate that, you know, we will, working with the controls, we'll filter out some of the noise, and you will hear, as the dispatcher heard just last week, as did other dispatchers here, as did I here, and as did other people in my office. You'll be able to hear them.
Counsel, we'll get to that. What I'm indicating, I want to see all the exhibits first. No, Mr. Harris is now here with our, the famous laser disc. Let me know if you're going to bring up the victim's body again. I hope the delay person caught that. All right, let me see the original, the full. Do you have the full report without the emphasized portion, Mr. Harris? No, that's... Okay. All right, counsel, just so we understand the parameters of what we're talking about here, as far as the question for reopening of opening statements by the prosecution, the issue was the court wanted to see the workout tape, so-called outtakes, that the prosecution wishes to present because the testimony regarding expert witnesses regarding the defendant's arthritic condition were not disclosed to them prior to the opening statements. Then also the prosecution wanted leave of the court to complete the pictures, quote unquote, as far as the EAP blood type. And I reviewed the exhibit just now. So let's settle the issue of reopening opening statements, and then I'll hear the 402 objections to the evidence. Ms. Clark, workout tape and the EAP item.
Tape was resolved
Right. Do you have anything else you want to say in support of the tape?
in support of the workout tape, Your Honor?
Yes.
Only, I think
All right. Mr. Cochran, those two items, laser disc and the workout tape.
Thank you, Your Honor. And I'll be very brief, Your Honor. With regard to the workout tape, I mean, we all saw the workout tape, and I think that I'll submit it, except to say that there was some moment of levity about giving your wife room or something like that. I don't know how that's relevant to anything at all. The latter part where Mr. Simpson is talking to the trainer apparently, and he's saying you have to give your wife room or something like that, or some statement when they're moving their arms. I don't know if the court noted that. I don't think that's relevant, and I think that could be ambiguous and misconstrued. Or you can turn the audio off at that point if you want to just show that. If the point is to show what he can do, why would you need the audio at that point? In addition to that, I still fail to understand what we said that would allow them to do this in a reopening, which is, the court has already said is so unusual. Because let me add this one thing.
Sure.
As I indicated to the court before, one of the advantages, and I think this seems to get lost so very often here, that who would know better than O.J. Simpson that he has rheumatoid arthritis, in addition to the fact that we do have doctors who are treating him. But I'm saying that we would know that, and so I don't know how they're prejudiced, and I don't know how this tape helps with the rheumatoid arthritis. He talks about his knees, he talks about those things. So I just wanted to point that out. I think that if you do think that it's relevant and should be done, it seems to me that I think we're stretching it, number one, but secondly, any conversation with regard to your wife or giving your wife room or whatever that statement was, you may want to look at that again. I think that would be improper, ambiguous, and would not be appropriate to be shown to the jury. The other aspect you asked me to address was with regard to the EAP blood. As the court can see, in the show and tell, it's locked into the laser disc. We put the whole exhibit up, took out the portion the court could see what we took out. That was shown to Ms. Clark. It was shown to everybody. This idea that they were rushing, well, that's not true at all. They were shown this, they looked at it, and with everything else, they continued to object. Even, to give you an example, Your Honor, this morning, Ms. Clark has this selective memory. She'd forgotten about the Furman thing. Out of abundance of precaution, I went back and told her again, Furman, she didn't recall that. You'll recall she argued about Van Adder, said we couldn't do that, and you'd already ruled on that. She will re-argue everything, and I think that's the point with his EAPB. We made that very clear, and it is absolutely outrageous for them to talk about misleading. We don't have to accept the fact that whenever anything points away from their theory of guilt towards innocence, and they want to talk about it being degraded, Your Honor, there'll be a lot of evidence about possible degrading. But that, again, that's their qualifier. That's their speculation. We don't have to accept that. We took the point that was made at that point, if the court pleases. And I think it's very abundantly clear.
All right.
First of all, with respect to the videotape, I think the statement that is made by Mr. Simpson is relevant and should be allowed to remain in.
Well, that goes to a different issue. You know, whether or not it's relevant to issues of domestic violence and flippant comments made about, spousal abuse, that's a different issue. You want to use it to reopen regarding arthritis. That's what you've asked for, not domestic violence. First segment deals with a workout. Second segment contains, I think, the comment, if I'm not mistaken.
Was it?
Since this is the first time I've seen it. All right, if the issue is the arthritis, at this time, I'm inclined to allow you to use the first segment only.
For the presentation.
For the presentation. Now, when
Why
we
don't
get...
we just take the sound out? Since the issue is the arthritis for the opening. Wouldn't that resolve it?
Right.
No, we don't want, no. Yeah.
Sure.
Absolutely not. Well, they want the sound out because he says, I've got these bad knees, you can't use these knees. I mean, what is this? I mean, I think that would be totally unfair.
First segment.
That's right. This is our case in chief, Your Honor. The council can put in whatever they want to put in when it's their turn.
Ms. Clark, here's the problem. The second segment clearly has problems with that statement. I'm not saying it's not coming in, but that's not the purpose you need it for the opening statement. All right? So you're asking for too much to get that in at this point. The first segment shows Mr. Simpson doing various exercises, stretching. He mentions the knees. That's what you need. That's what you want for your opening statement. That's what you can have.
Is the court requiring us to use sound?
That's what it is. You want a videotape, you take it the way it is.
Your Honor, if we don't want to use the sound, it's easy to take out. We can simply show it. That's
But
how
then
I saw it.
But then it's a misrepresentation of what's there, isn't it?
I'm sorry?
Then it's a misrepresentation as to what it is.
Kind of like what counsel did, you mean?
Do you want to use it or not? Yes or no? Use the videotape, don't use the videotape. It's up to you. First segment, that's all I'm going to allow in because that's all it's worth. All it goes to is the arthritic condition. Sure. Okay. Second thing is the EAP, the thing on the laser disc. I've seen it now. Any other comment?
I think the court can see how misleading it is. And I only wanted to indicate to the court that the defense violated the court order regarding the show and tell, showing up late with it on Monday. I do not recall having seen it, but we were hit with so much at the last minute, and as a result of the defense violation of the court's order as to when those exhibits were supposed to be shown to us, we were pressed into examining a huge number of exhibits, all at the last minute, with about seconds for each one. The result of a defense violation of a court order should not be that the people are under the gun and held their feet to the fire. That should not be the result. The people should be entitled to examine things in a more leisurely fashion. And the defense is simply pushing the court and pushing the court in order to get the court to push the prosecution unfairly in order to gain more tactical advantage, which is what they did exactly with the exhibits as well. It's a very consistent pattern here. We have a constant effort to sandbag and take the prosecution by surprise and try to make this a trial by ambush. They don't want the truth to come out. They want to put a stranglehold on us so that we cannot meet their evidence and meet their representations. And that's why everything is being hidden and popped out at the last minute. Too many last-minute surprises. And nobody's perfect, Your Honor. If we made a mistake, then I apologize to the court. That's what happens when people do things in a hurry. Mistakes get made.
Thank you, Ms. Clark. All right, the court's ruling, I'm sorry.
The court, this was argued on the 23rd. The court didn't even rule on this till the 24th, I think you'll find the record will show.
All right, counsel, the court's ruling stands as to the prosecution motion to reopen. They will be allowed to reopen as to Ms. Gerchis. As to the inconsistent statements, they will be allowed to reopen to show the first segment of the workout videotape. They will be allowed to reopen as to Mr. Weitzman, since Mr. Weitzman was neither on the witness list or disclosed prior to the opening statements. I am going to sustain the objection to reopening as to the EAP blood type. All right, let's discuss then in the opening statement, the prosecution's first witnesses and evidence. Certainly. Clarification question?
Question.
Yes.
The question has to do with, the court indicated that he wasn't on the witness list or whatever. I'm indicating to the court he wasn't on the witness list, but for the prosecution to make this statement, I'm representing this court that Mr. Weitzman is going to say, along with Mr. Tamm, that he was asked to leave and was not allowed in that room.
And I assume that they're going to say that defense counsel made this representation to you. We're going to present witnesses who are going to tell you that that's not true. This is what our evidence is going to show, and that's all they're going to be able to say.
Okay, I just want to make sure, because Weitzman's going to, for a lot of us, he's going to be coming in along with Skip Taft and others who are going to say what actually happened.
I suspect so.
Thank you. Just want to make sure that was clear.
All right. No, it's crystal clear.
Okay, thank you.
All right. As to the Roy Firestone tape, any comment, Mr. Cochran?
Yes. We're now to the trial evidence, Your Honor.
That is correct. Two issues we're talking about here are the 9/11 tape and the Roy Firestone tape.
Well, let me then take, you asked me about Roy Firestone first. Let me take Roy Firestone first. It's a television interview, Your Honor, and I'm not clear for what purpose this is offered. It seems to me that if they're going to call Roy Firestone, I'm not sure they're calling Roy Firestone or they're just going to play the tape. Seems to me they'd have to call Roy Firestone as opposed to just playing the tape. Or is there going to be a combination thereof? May I ask that question first? It has some relevance. You're just going to play a tape, and is that all that's going to happen?
I don't know. Mr. Darden?
Well, I think the tape is self-authenticating. I don't think I have to call Roy Firestone. It speaks for itself. Either that's O.J. Simpson or it's an imposter.
Well, the problem is, how do we cross-examine the tape? That tape is cut after an interview. When you go, if the court's aware, when you do an interview, well, I shouldn't use that as an example, should I? Forgive me, Your Honor. When one does an interview, sometimes they last like 5 days or whatever. You know, let me tell you, Judge, they cut these interviews.
Oh, Mr. Cochran, you really know how to hurt a guy.
No, Your Honor, no. What the point I was trying to make, Your Honor, was that this interview is cut in a particular fashion to be shown over, let's say, a 22-minute period of time if he has a half-hour show. We can't cross-examine that. I'm sure that Mr. Simpson, as he sees that interview, will say, wait a minute, they cut this other part out that I said. If we have Roy Firestone, because otherwise it becomes hearsay, a form of hearsay. If we have Roy Firestone, I can ask him, well, didn't Mr. Simpson say so-and-so in addition to that? So we don't have that. So that's my first objection to this. I mean, I think that, again, as much what they do, it seems like it's much ado about nothing, but it seems that here's an interview in '89 where they're going to show the tape without Roy Firestone. And, Judge, I just think we'd be entitled to have Mr. Firestone as part of their case, because I think otherwise it's hearsay. I cannot cross-examine or show the circumstances of this particular tape. And I think that's unfair to the defendant. We're deprived of our constitutional right in that regard.
All right, what are your comments on the 9/11 tape?
The 9/11 tape, Your Honor, I was a little surprised to hear Mr. Darden say he's going to clean that up. Now, here we are.
I didn't say that.
I thought he said he was going to cut something out of it or
I
do
didn't
something
say
out of
that
it.
either.
He said something about doing, don't talk to me. Your Honor, I'm talking only to the court. I thought that Mr. Darden said something about cleaning something up or whatever. We don't want that tape altered. And I'm telling you, Your Honor, and I'm sure you've heard a lot of tapes in your life, and for him to have gotten up and said those were slaps, I think that that's going to be a major problem for him. I don't think that any dispatcher can talk about these being slaps. I think we have a further hearing regarding that person's qualifications. Based upon the tape that we've heard, I would ask the court whether or not this court is prepared to allow anybody to testify those are slaps. Certainly didn't sound that way to me.
All right, do you have any problem with the screaming woman in the background?
Well, I don't, no. I mean, if there's somebody who's screaming, if it's identified with this case, you say I have a problem with it. I'd rather not have that, of course, but I mean, I don't have a problem with it from a standpoint of their order of proof, if that's what they're trying to do. But he got up and told the jury they were going to prove slaps. I don't hear that. Then he tells us today the dispatcher can hear it, he can hear it, and he's going to do something with it to make it clear. And I don't think that's true at all. That's why we have these 4-3 hearings. So I do object based upon that, Your Honor. Until it's something that's relevant, it's something that's not speculative, and Your Honor, I want you to note that I'm not asking to reopen my opening statement so I can say that, gee, he misled this jury. Sometime or other we got to try this case, don't we?
Well, I hope so. Mr. Darden, let me ask you this. As to the Roy Firestone tape, I seem to recall that I sustained objections to the defense using a montage of videotapes, which I could tell were the crime scene at Bundy. I recognize the persons who were there, but we don't know where, when, how, and whether or not they're outtakes. And there's a foundational problem with it that the prosecution advanced, and I sustained that objection in your behalf. Mr. Cochran raises the same objection to the Firestone videotape. It is apparent who's there. It's Mr. Simpson, it's Mr. Firestone, and they're talking about the '89 incident. But there is still an authentication foundation that has to be laid. It is not inherently self-authenticating.
I think that it is, Your Honor. In discovery and during the DV hearing, I provided the court and counsel with a complete copy of the program, okay, and that is a portion of that program. And so whatever concern Mr. Cochran may have then regarding the authentication of that particular tape, there's no issue there. And you can't cross-examine a videotape. That's absolutely correct.
Well, here's the problem,
but he can't
Mr.
put
Darden.
on a defense.
There's an objection. There's a foundational objection is what I'm hearing from
What
Mr. Cochran.
is the objection? He has a complete program, and I want to play a portion of it. I have no duty to play the entire program, especially given the fact that it's not relevant to these proceedings. And so I want to play 4 minutes of that program that relates directly to an incident which the court has agreed is relevant and admissible in this case.
All right. Well, Mr.
Okay.
Darden, let's assume that I don't buy the argument that it's self-authenticating. Where does that leave us?
You're the judge. That's where it leaves us. I say it is. I say the evidence code would likely agree with me. I mean, it's a portion of a complete TV program which the court has seen, and which Mr. Cochran has seen.
I have the evidence code before me. You want to cite me to a code section that says that videotapes are self-authenticating?
No, I don't.
Well,
No,
you,
I
I
don't.
mean, you put me
No,
in
I
a-
don't. But it's like any other writing. Okay, videotapes, like writings, can be self-authenticating. Okay, you have the date of the interview right there. We recognize the people in the videotape. They're identified in the videotape. Okay, we know the date that it was aired. We know it's an ESPN video.
Well, I agree with you. I know all these things. The problem is that they're objecting.
I'm helping them out. I'm trying to show them where they're wrong.
Okay.
Look at the videotape, the content of it. You want to know who produced it? You want to know the date of the interview? You want to know the subject matter? You want to know the name of the interviewer and the interviewee? It's all right there. What can be more authenticating than that? It's right there in front of us.
Well, isn't what's in there, the date on it, hearsay until somebody authenticates it?
No. Would it be in a letter? Couldn't the letter be self-authenticating?
Depends on what
Does
the letter
someone have
is.
to come in and authenticate the date? I mean, the letter speaks for itself, just like the videotape speaks for itself.
But we just can't bring in letters. Somebody still has to testify who wrote it, whose handwriting it is.
Except that in this case, you don't need that because you see the faces of the persons who are speaking. You see the face of the person who is asking the questions. I mean, if you want someone from ESPN in here, fine, okay? I mean, that's fine. That's no problem.
No,
I'll get
it's
someone
not
from
me
ESPN.
who wants it. They're raising the
okay.
objection. I just as soon leave the ESPN people at home.
Sure, I'll get a clerk to come in and say, this is a program that aired at ESPN. This is a TV program. This is our videotape. It's a true copy. And that's that. And that's all that's required under the law.
All right, and what's your response to the screaming woman aspect, the slapping aspect of the screaming woman tape?
Well, I think that lay people can give their opinions. I'm not going to cut the tape or alter the tape so that you can hear slaps. I'm simply going to adjust the dials on the tape recorder here. If there are no slaps, the jury will figure that out. But let me add this. You have the tape of the screaming woman. You have the operator saying that the call originates from 360 North Rockingham, and you have her dispatching police cars to that location. You have officers arriving moments later. You have Nicole Brown Simpson, who has evidence, physical proof of having been slapped, plus you have her spontaneous statements. Okay. I think that when you look at the totality of the circumstances, I think, A, you're going to hear slaps as we adjust the knobs on the tape. But then again, there's also physical proof that the defendant slapped her, and he admitted it later on. I mean, he admitted harming her in his letters to her. So, what's the issue? What's the problem, Mr. Cochran?
All right,
Yeah,
briefly.
some of the problem is the evidence code is to the California. That's the problem. And hearsay and other things like that. I mean, it's not productive to tell you that you're going to hear slaps. He's told the jury that already. We've all heard this tape, and you're not going to hear slaps. It's a matter of interpretation. What I think we should make very clear, Your Honor, that counsel needs to read the evidence code with regard to that videotape and regarding, because there's analysis of that in the letter. That is not foundational, and I think we still have a problem. And I don't think you can just bring a clerk in here who, so we're going to object if brings a clerk in here to try to lay some foundation for this particular tape. As you correctly pointed out, Judge, when we were seeking to show a tape which everybody had seen at the scene, the court kept that out on various grounds, but it was a montage. These things are cut, pasted, put together, and it's a real problem if we don't have the person who did the cut and pasting. If we're talking about a truth and getting the facts out to the jurors, in which they claim they want to do. So I would reserve further objection. And I was reminded when I returned to my seat that what counsel had indicated was they were going to filter or something, use the words filter, with regard to this noise. We're entitled to have that tape just the way it is, not enhanced, and not just fiddling with the knobs, but the way we heard it here, not so they can bring up something to try to prove something. Further, there's a foundational problem with that tape. The address I think I heard was 360 Rockingham, apartment B. And there's no apartments at that location. There are no apartments at 360 Rockingham. I don't know, I'm not clear about what's happening with regard to that. But I think that there are some further foundational things, and I appreciate the court. That's why we have these hearings. But counsel has not given you asking for a case, asking for a cite with regard to the videotape, and you know the problems inherent with this tape. And this is just, they haven't even called that first witness yet, Judge, and these are the problems they're having with this evidence.
All right, thank you, counsel. Mr. Darden, I think you have I accept your offer of proof that you're going to have the dispatcher come in who was the person who took this call, correct?
Yes.
All right.
She will explain the B. I'm sure not to Mr. Cochran's satisfaction, but I'm sure to everybody else's.
All right.
And she will authenticate the tape. She'll also indicate that as she listened to the slaps and the beating, that she typed into her keyboard there contemporaneously that fact, the fact that she could hear the woman being beaten.
Is that part of our record of discovery? Has that been turned over to the defense?
Absolutely, Your Honor. Well, he should read his discovery.
I've seen that, Your Honor.
He should read his discovery.
And I'm not seeing it. Furthermore, the fact
Well, he
that
hasn't
she-
read it.
That's-
I'm at the-
Oh, hold it.
I'm-
I'm talking to Mr. Darden right now. Mr. Cochran.
That's your answer.
All right.
Of course, it's part of the discovery, Your Honor.
All right. Mr. Darden, accepting your representation that you will have the dispatcher here who will authenticate the tape, I'm going to overrule the objection at this time.
Thank you.
However, the tape appears to me to be overly long because it goes on to other things and other incidents and other. How far into the tape do we get the actual dispatch of the unit?
That process, from the time that you hear the first scream until you hear the dispatcher notifying police
Any West
units.
LA unit,
Yeah.
360 North Rockingham, code
Yeah,
2.
right. It's
High.
about, yeah, it's about 3 minutes. And the problem here is that the dispatcher receives the call, she hears the screaming, and as I understand it, the line is left open. Okay? And so although you may hear other dispatchers coming on and dispatching other units to other locations and other matters, the line is left open and the dispatcher is still listening in.
All right, the
At
tape is
Rockingham.
relevant up until the point where the car is dispatched, but there's a lot of extraneous stuff that's going on there. So what I'm telling you, I'm going to let you play the first part of it up until the point we get to the actual dispatch of the car, because I think that pretty much ends the relevance of the tape.
So you're saying that once the cars are dispatched to Rockingham in the tape?
Right.
Oh, fine.
Question, Your Honor.
Yes.
Is the court allowing the dispatcher to say she heard slaps? I don't think we rejected that. I don't think we ruled on that yet. How is she able to make that determination?
Let's talk to her when she gets here, out of the presence.
If I'm bored out, well, I asked
Let's
counsel
see.
not to.
And Mr. Darden, why don't you pull up your, the sheet that you have on her notes, and we'll take a look at it tomorrow morning. All right?
Your Honor, when you hear that, who was slapping whom in that tape?
I don't know.
Looks like OJ was slapping, looks like the defendant was slapping Nicole. I don't know. That may be the point in time when he grabbed her around her neck and left the hand in front. I don't know.
All right, that's enough, counsel. All right, as to the Firestone tape, I'm going to sustain the foundational objection subject to further proof.
Thank you.
Okay, tomorrow morning then, so that we're clear, tomorrow morning at 9 a.m., the prosecution will have 10 minutes to briefly reopen their opening statements, then we will proceed to the presentation of evidence.
Portion of the
Yes, in addition to the
exercise.
4 minutes of videotape that's relevant. Mr. Bailey,
Report at the bench just for 1 minute before you.
do you want the reporter? All right, we'll recess 9 o'clock.
Before we do, I just wanted to...
I'm sorry. Ms.
Just for the
Clark.
record, I wanted to clarify the court's ruling. With respect to sustaining the defense objection to addressing the blood, is the court making a finding that the defense exhibit was not misleading?
No, I'm making a finding that we had 2 days of show and tell, that the prosecution has many lawyers available, at least two, perhaps three who were assigned to the blood evidence, that the purpose of the show and tell was for counsel to look at these things and to raise any objections. No objection was raised. It's too late at this point in time to ask to reopen as to that issue. That's the reason for the court's ruling.
But how would we have known that he was going to
You're
use...
just asking me for the ruling, counsel, not arguing. All right, I'll see counsel at sidebar.